the rule of law for the internet, and the floor is yours.
Thank you. Thank you. Good afternoon, everyone. It's nice to see a group of people interested, rather than this just a little smattering of one or two. And I'm going to start by, I always break all the rules. The first thing is never start by apologising. So I'm going to apologise. There isn't a paper. This is a seminar without a paper. My excuse is I've been busy. I know we've all been busy, and I know it's a really poor excuse, but it's the only one I've got, so I'm going to stick with it. I'm also going to apologise to at least, I think, 2 people in the room who will have heard bits of this before at Bileta events or events that occurred in Leicester last year. So for those of you, feel free to fall asleep at the relevant points, but don't snore too loudly and put everyone else off. So the idea of this afternoon, and what I'm going to do, by the way, nobody actually told me how long I had to speak for, so I'm going to speak until I get to this page, which is the end. And if anybody does have to leave in between, then I understand. It should be before 6 o'clock, so don't worry about it. So what I'm doing today is talking a little bit about, I suppose for those of you who don't really know me, a little bit about who I am before I start. I've been at the LSE now for 14 years, and in all that time I've been there, I've sort of been the person who teaches and researches in the field of information technology and the law and related aspects. And I started out as many, what I will now call cyber lawyers, by being an intellectual property lawyer. I was a trademark lawyer who in the mid-late 1990s wrote a paper about trademarks and domain names, just at the point that that was becoming a thing. And then one of the largest firms in the UK threatened to sue me for defamation, so I knew I was onto something at that point. And so I stuck in that field. They never did sue me. It was very good. It was a paper I wrote for the European Intellectual Property Review, and I got a panicked phone call from the editor saying, "This firm are threatening to sue for defamation. You've accused them of professional negligence. Why did you do that?" And I said, "Well, because they were professionally negligent." And they said, "What are we going to do about this?" And I said, "Don't do anything. They won't sue. Are they really going to sue a penniless lecturer at Stirling University?" But she was quite worried, obviously, because they were Sweet Maxwell. They had a real cause to be worried. I didn't. So it carried on, and then I said, "Tell them they can write a reply, and you'll publish it. They'll love that." Okay, so she went back to the senior partner of this city law firm and said, "We'll give you the chance to write a reply." And I said, "But tell them that I'll get to see it and I can write a reply." And stupidly they agreed. So they wrote their reply and I wrote my reply to their reply, which were published side by side, which really didn't help their case any, because they had defended themselves. And I said, "Well, they said this, but why didn't they do this?" And anyway, that was the last I ever heard of it. But from that point on, I was really excited by cyber law. I thought any field of academic study where you can get threatened by litigation has got to be the one to go into. So since 2000, I've been at Stirling University and I've done cyber law related stuff. And probably I'm best known for doing the regulatory theory surrounding the internet and online activity, and probably the book that got most attention is called The Regulation of Cyberspace. And now I'm probably best known to students for writing a nice big thick textbook on information technology law, which doesn't pay as much as OUP tell you when you write it. It's just warning for anyone who's considering doing those kinds of things. So what I'm doing today is talking about the role of the cyber lawyer as a lawyer. And so it's in 2 halves essentially. The first part, which some of you will have heard actually by Bileta last year, is kind of starting out by talking about the role of the cyber lawyer. And then the second part is talking about maybe where we need to go next. And this eventually will form a paper that hopefully will make sense, but probably won't be done until at least the end of the year. So if anyone's got anything to feedback, I look forward to it. So my starting point today is by looking at what the role of the cyber lawyer is and who the cyber lawyer is. And I start by saying that cyber lawyers have always actually been on the wrong foot. And we've been on the wrong foot ever since 1996. And the reason we've been on the wrong foot ever since 1996 is because somebody put us on the wrong foot all the way back at that starting point. And that person was a chap called Frank Easterbrook, who was a professor of law and economics at Chicago University, a judge, and many other things. And he's known for his weddedness to efficiency within law and economics. Now, Frank Easterbrook at that Chicago conference in 1996 put us on the wrong track, and I'll explain why in a minute. Essentially, if we are lawyers, or we think of ourselves as lawyers or legal academics, our normative position as legal academics is that the law evolves, but the way we usually study it, and the way we limit our studies, is how it evolves within substantive boundaries. So, I mean, I don't know everybody who's here today. You might describe yourself as a criminal lawyer, public lawyer, torts lawyer, property lawyer, intellectual property lawyer, commercial lawyer. I don't know how many people, or anybody, who works in legal academia now who says, I'm a lawyer, and I know everything about every area of law, and I can keep abreast of all. So the way our discipline is organised is within these normative boundaries which follow on from the normative legal structures. Very occasionally, these normative legal structures will be broken within the academic discipline, and we follow a vocational model. So the most obvious one of the vocational model is media law, for example. But there are others: telecommunications law, financial services law. So we have a small number of vocational subjects. But generally speaking, vocational subjects find it hard to gain a foothold and grow roots in the academic discipline. Now, the emergence of information technology law, computers in the law, and the internet in the law, led or has led to a slow evolution of the concept of cyber law or information technology law. And it has a long history that people don't always appreciate. The first book that I can find specifically in this area was Colin Tapper's book in 1978. So it's been going a long time. There are others who then followed. Chris Reed wrote his first major book in the area in 1990, Ian Lloyd in 1993, David Bainbridge in 1990. But if we look at these early books in this area, what we find is that they're not really cyber law books or computer law books. Instead, they're what you might call computer world problems, looked at through a legal lens. So they have chapters on things like computer contracts, computer evidence, data protection, computer software, copyright, computer-based expert systems. So all they have done is taken these traditional normative legal structures and put a chapter on each of them into a book with the word computer. So there's no real cyber law there. The cyber law doesn't exist. That all it is computer applied to normative structures of law. So therefore, you can make an argument that cyber law doesn't exist, which I'm willing to accept. It is great, because it means if cyber law doesn't exist, I've been paid by the LSE for the last 14 years for doing something that existentially doesn't exist, which is quite nice in some way. So you can make this argument it doesn't exist. It's not a true substantive legal subject like media law, telecommunications law, financial services law. It's not any of these, and it's definitely not an old-fashioned substantive subject. It certainly doesn't have these foundations. So where do we go to sort of define what we are? How does cyber law exist then in this kind of vacuum? Well, this is where Frank Easterbrook comes in 1996. There was a conference at Chicago University organised by, among others, Lawrence Lessig, called Law in Cyberspace. Frank Easterbrook was invited to come along. It's fair to say he wasn't a fan. And Frank Easterbrook made a speech which has now become famous, called Cyberspace and the Law of the Horse. So I think because everybody has to hear a little bit of Easterbrook, here's a couple of bits from it. When asked to talk about property in cyberspace, my immediate reaction was, isn't this just the law of the horse? I don't know much about cyberspace, which I think is fair, but what I do know will be outdated in 5 years, if not 5 months. And my predictions about the direction of change are worthless, making any effort to tailor the law to the subject futile. And if I did know something about computer networks, all I could do in discussing property in cyberspace would be to isolate the subject from the rest of the law of intellectual property, making the assessment weaker. So, in essence, I don't know enough to make a real assessment, and if I do try and do something, I take property law out from the normative legal analysis of property law, and that weakens my understanding of it. He then goes on in a very sort of clear and lengthy quote, which I won't read all of it, to explain why he thinks cyberspace law doesn't exist. When he was dean of this law school, Gerard Kastler was proud that the University of Chicago did not offer a course in the law of the horse. He did not mean by this that Illinois specializes in grain rather than livestock. His point, rather, was that law and courses should be limited to subjects that could illuminate the entire law, instead of offering courses suited to dilettantes. So his basic thesis is that any of these law ands are basically impure. They're not actually the study of law any longer. And what you're doing is you're mixing your study of law with something else. So Easterbrook sets a sort of long shadow in place right from the start. Academic lawyers interested in this area were on the back foot. Immediately, Lawrence Lessig sort of responded by writing a paper called The Law of the Horse, or What Cyber Law Might Teach, which was eventually published in the Harvard Law Review. But it was a very defensive response to Easterbrook. It was about saying, there's something special about cyberspace, and something special we'll come to in a second. It's what he called the New Chicago School. And this is a way for us to understand cyberspace and cyber law, and as lawyers to benefit from it. But it's very defensive. Easterbrook immediately, and still I think to this day, casts a long shadow over cyber lawyers and all of our work. We continue to either consciously or unconsciously be affected by what he said that day. We're kind of split into two groups. That's mainstream cyber lawyers are in two groups. One is the regulatory cyber lawyer. That's where I belong, and there are others. Roger, amongst his many bows, many strings to his bow, is in this area as well. So we have this regulatory cyber lawyer who actually looks at regulation in cyberspace, the sort of wider picture than just law. The other is what you might call, and I can't think of a better word for it, the applied cyber lawyer. These are the people who do things like cyber privacy, cyber indecency, e-commerce, cyber defamation, and basically they have chosen to specialize within an area of cyberspace and law. So I say both of these are in this Easterbrookian shadow. It's more obvious in the regulatory cyber lawyer, where the spiritual leader is Lawrence Lessig, or was Lawrence Lessig. He answered the Easterbrook challenge with his New Chicago School in the Law of the Horse, and he introduced us to what he then defined as his famous, he didn't define it as famous, we defined it as famous, modalities of regulation thesis, where he says, cyberspace is distinct from real space in the way it's designed and the malleability of code. The design of the environment we learn as lawyers by studying cyberspace problems and cyberspace law is educational, not just to cyber lawyers, but to other regulatory theorists. Now this, of course, simplifies Lessig's position massively, but we don't have time to go through Lessig in detail. And I have written elsewhere that I think Lessig didn't actually rebut Easterbrook, just kind of pled special circumstances. But what he did is he kind of led us all in a particular direction. Instead of being cyber lawyers, we all became cyber regulatory theorists, because this was a way that we could contribute. By understanding regulatory theory rather than the narrow discipline of law, it was a way for us to contribute. And it's produced some really good work. I've written my book, The Regulation of Cyberspace. Others have all been in this field. The late, great John Bain was in this field. Lee Bygrave was in this field. Roger Brownsword, Tim Wu, Jack Goldsmith, Ian Brown, Chris Marsden, Hans Thompson, Paul DeHert, many, many others. All names that you could check, who have done some really great work in this area. Again and again, we keep coming back to the same, they've done really great work. You can cite that I've done great work by reading my own work. I still realise I talked myself up a bit there. Again and again, we return to the same well, and we discuss unique characteristics of digitization, unique characteristics of cyberspace as a place, cyber regulation and governance theory, and we all start to employ these great academic heavyweights. So you see people talking about, well, what would Michael Foucault say about this, Michael Foucault say about this? What about Bruno Latour? Well, he must have a role in this. Nicholas Lohmann, I've used Nicholas Lohmann myself. It's wonderful to use Nicholas Lohmann because very few people understand what he says. So you can almost claim anything, and people will just say, wow, gosh, that's great. And then we apply, these are not lawyers, then we apply the legal academic cruiserweights. Anybody who uses Nicholas Lohmann then falls back on Gunter Teubner, almost reflexively. Cass Sunstein, Neil McCormack, others, to try and make our point about cyberspace and cyber regulation. But we continue to use the language and rhetoric of social policy, sociology, and political philosophy. We continue to refer to literature communications theorists like Manuel Castells, Nicholas Negroponte, Robin Mansell, We apply things like Luturian, Foucaultian, Frankfurt School language, and so we have become, I would argue, social scientists and not lawyers. We've kind of moved away a little bit. In essence, those of us who have followed the New Chicago footsteps prove Easterbrook's thesis. There was no role for a cyber lawyer. Instead, it has become a lens for the study of governance and regulation. We're not cyber lawyers any longer, we never were. We're now cyber political scientists or cyber political theorists, whatever you want. And this was brought home to me by a colleague who said to me once, but what you do isn't law. You know, it isn't. And I thought about it, and it's true. I could be in any kind of social science department and do what I do and mostly fit in. I do work and research and talk to and exchange with people like Robin Mansell, who works in media and communications, Ian Brown, who's an information systems individual, John Naughton, who's a systems engineer. So we don't have to be lawyers. So this got me thinking again about what we're doing and the difference between a textbook in cyber law or a theoretical book in cyber law and one that more mainstream lawyers do. So if you look at a property law text, it will probably cite the likes of Bentham, Burke, Dworkin, Hart, Hegel, Honoré, Hofeld, Hobbes, Kelsen, McCormack, Posner, Raz, and Waldron. I know they do, that's James Penner's book in property law, amongst others he cites them. A criminal law book are likely to cite Bentham, Blackstone, Denning, Garland, Hart, Honoré, Horder, Kant, Locke, and Williams. That's Jeremy Horder's book. A cyber law text doesn't really cite any of these people. Very rarely do we refer back to traditional legal jurisprudence. Instead, we will be citing people like Latour, like Luhmann, all these kinds of people who are not actually lawyers. And so the truth is that, you know, we're not actually dealing with legal subjects. This group of people, these cyber regulatory theorists, and we tell ourselves all the time, this is good, this is brilliant, we're the ones in the right. You know, while our colleagues sit in these dark and narrow confines of legal orthodoxy with a very small candle to guide them forward, we're outside in this great light and bright world where we see communications theory, political science, and all these things. But from the outside, property lawyers and tax lawyers are looking at us and just kind of scratching their heads and saying, what are these guys doing? They're not actually lawyers. So then I thought maybe the real cyber lawyer is the other type of cyber lawyer, the person like Paul Bernal, who's one of my ex-PhD students, who does brilliant stuff on privacy and cyberspace. So maybe that's the kind of person that we want to have. So it's not really my area, so I kind of had a look at what they do. And I think, you know, mainstream privacy lawyers, they certainly don't disrespect cyber privacy lawyers. They find it very useful. But then I remember Easterbrook's challenge, sort of as amended. All I could do in discussing privacy in cyberspace would be to isolate the subject from the rest of the law of privacy, making my assessment weaker. And I think the same is true here. To privacy lawyers, the cyber privacy lawyer is a valuable colleague. They're the person who understands things like networks, social network platforms, internet service providers and blog hosting and all this kind of thing. And it's the same thing having to learn this, but they don't see them really as illuminating the wider sphere of privacy law. And I've seen this, I've been to privacy conferences which both are present at. And the privacy lawyers think it's really great to have somebody there from the cyber privacy field, but then they go away and get themselves ensconced into their rights-based discussion, and they kind of forget the digital side. And if you look at things like libel and defamation law for a second, cases like Timiz versus Google are generally interesting to libel lawyers, but not important. They don't illuminate their understanding of libel law. So I think it arguably fulfills Easterbrook's claim of multidisciplinary dilettantism, the cross-sterilization of ideas where one puts together two fields and gets the worst of both worlds. So everywhere you look, we're kind of fulfilling the view that Easterbrook put forward. So, you know, this is the point where you're now all feeling depressed, you're all feeling down, you're all thinking it's a lovely day outside, I could have been sitting outside with a coffee. Sorry, you're...
Can I clarify?
Yes, of course.
Do you want interruptions or not?
I can do, yes, no, it's fine. Yeah, go on.
And the second thing is to point out that not everybody is a lawyer.
Right, yes.
And I found myself struck by what you were saying in an odd way. Isn't what you're arguing, in effect, that the lawyers have got it wrong, and that connecting these issues to the lives of real people is a matter of sociology and politics and economics, and yes, the law becomes a structure imposed on those things to create order out of the chaos of all of that, but it is all connected. And that the lawyers who look at things by themselves without paying any regard to the rest of the world have missed the point.
That's,
Is that,
yes,
I didn't
that
think
is
this
fair.
major conclusion.
Yeah, no, that is fair. It's actually not. What I'm doing today is going quite different because that would be my natural conclusion, is that the problem is not what I will call cyber-regulatory theorists do, is the problem. The problem is that lawyers tend to be very insular. And this is because my feeling behind this is that law has its own philosophy. Law has its philosophical foundings in jurisprudence, hence that list of names that I rattled off that property lawyers and criminal lawyers see as their touchstone. And law has its own, as separate to the other social sciences, has its own normative structures, which are actually very different to communications theory or political theory or any of these other, what you might call wider and more expansive theories. Now, people like myself and like Roger and others who tend to look outward, I think we are doing the right thing. And I think the problem is not what we're doing, the problem is what traditional lawyers are doing. What I'm actually going to do, you haven't prejudged this conclusion, because what I'm going to do in the second half of this is I'm actually going to try to see how we can maybe talk to lawyers. Because the trouble is that lawyers don't listen to us fully. We're kind of a slight outlier tribe within our own community. You know, they're the regulatory theorists, which is all fine and dandy, but at the end of the day, what would Herbert Hart say about it, kind of thing. So I'm afraid the second half will be a bit kind of legalistic and will refer to legal theory, because I'm trying to find a path to speak back to lawyers about it. But you are right, I mean, it's going to sound like I'm saying that somehow or other the traditional lawyers have got it right. What I'm actually saying is about this label of being a cyber lawyer. Can you be a lawyer who's in this area? Or do you have to be something a bit wider? Can you talk to the legal community? Can you be a bridge? That's kind of what I'm going to get to. And I started. I did realise there were people who weren't lawyers, and I just kind of became a bit lawyerly in my approach. I do apologise for that. But no, anybody who wants to stop at any time, sorry, just do stop, and I mean also chat at the end as well. So where have I got? I don't believe cyber law is a cul-de-sac subject as a legal subject. I don't think that is true, and I also don't believe it's impossible to define it in terms of legal research and study. Legal normative principles I think can apply. So what we do notice is that cyberspace is becoming more and more central to things we do daily. In fact, there are certain things now that it's very difficult to do without some kind of connection to the network. Even simple things like trying to pay your congestion charge in London is pretty hard if you don't either do it online or by text message or something like that. Actually, finding a shop that will take money from you now for it is really difficult. So cyberspace and the network is becoming more relevant to us every day. And lawyers, this is regulatory, professional lawyers, not academic lawyers, have now become much more involved because there are major issues that many of us talk about. Indecency, harm, taxation, privacy, security, both financial and personal, are now heavily legislated for by governments. So there's a whole plethora of programs, both at European and UK level, in a number of areas. And of course, taxation for online activity is a major issue that governments are trying to sort out at the moment. You know, you've got some governments offering tax breaks, and some governments complaining about the lack of collection of taxation in the online environment. And although maybe it'll be a little bit of time until sort of internet regulation and cyberspace actually displaces Kim Kardashian on the front page of the Daily Mail website, it is talked about by the media. Some things the Daily Mail gets very vexed about. They really are worried about children viewing pornography, which I think the best first step they could take would be to close down their own website, if that is their concern. Because it's hardly a paragon of family virtues, their website, but that's by the by. So if we take one example, the measures to deal with illegal file sharing. The dominant legal plank which is dying on its feet is the Digital Economy Act. It was designed as a response to this, and it's absolutely dying on its feet, and so are other moves elsewhere. When that came about, it came about as a response to the Digital Britain report, which was produced by a committee chaired by Lord Carter of Barnes. So this is a major issue of cyber law and cyber regulation. This is something important for government, important for us. So, of course, you think you need to engage with cyber lawyers to understand it. Well, it was a committee of 25 civil servants and a steering board who produced the draft and the report. They were Peter Black, a network engineer, Tanya Byron, a clinical psychologist, Francesco Chow, a banker, Andrew Kitty, a digital media producer, Barry Cox, a journalist, Matthew Dancona, a journalist, Robin Foster, an economist, Andrew Gowers, a journalist and banker, Ian McCulloch, a broadcaster, Peter Phillips from Ofcom, and Stephen Temple, an electrical engineer. So we've got 3 journalists, 2 bankers, no cyber lawyers. So we're not being taken seriously, not just by the legal academic community, but also by the regulators. They're not talking to us. They're not seen as important. Another one, the Joint Committee on Privacy and Injunctions. The driving force behind that was the events of spring 2011, what I call the Twitter spring. This, you all remember, this was the great spring where we all decided we would all try and identify which footballer had been sleeping with which model, which actor had been having an affair and all this kind of thing, and the heady days. Now, this committee came out of all of this. It was about sort of privacy injunctions being breached daily by Facebook users, Twitter users, Wikipedia users, and others. The committee had 3 specialist advisors, very good people all. Eric Barrett, who emeritus professor of media law at UCL, Sir Charles Gray, a former High Court judge, and Paul Potts, visiting professor of journalism at Sheffield University and the chief executive of One Time Press Association. Old media was represented throughout, but no cyber lawyers. There were 27 days of evidence gathering given over to old media interests and 3 days to new media. And of these 3 days, one of them was with Paul Staines, who is known as Guido Fawkes. And all they wanted to know was how they could shut him down and shut him up. That was really all they wanted to get, and he told them to bugger off. He wasn't going to be shut down. So I've been thinking, how can we perhaps start to talk back to the UK legal academic community and to the regulatory governance community as lawyers, because they're only interested in us as lawyers. They don't want to hear from us as theorists in regulation, because if you're a politician, you are the regulator. You don't need to hear from a theorist in regulation, except for in niche areas, like Julia Blacksall getting phoned up for how to regulate financial markets. But that's a niche area. So I kind of thought about this, and this comes to the key bit, which is this mapping the rule of law bit. When we act as cyber lawyers, either niche or the sort of wider regulatory theories, we make certain assumptions, and I think these assumptions might not be true. For example, we assume that the Defamation Act 2013, as applied specifically to online activity, not more widely, is a legitimate act of the UK Parliament. That's not really an unfair assumption to make. It was passed by Parliament, and the UK Parliament draws authority to regulate and control our acts from a number of sources. So this is where it all gets a bit more legal. So it depends on your flavour of your legal beliefs. If you're Austinian, there aren't many of these about these days, but if you're an Austinian, you will say that the Parliament is sovereign as the Queen in Parliament. So the Queen's authority is drawn down to Parliament, and they make her law in her name as a sovereign. The acts are therefore laws. If you are a Harshian, if you're a follower of H.L.E. Hart, you might follow a simpler sort of rule of recognition and say the relevant officials who are judges recognise the law, or the act, sorry, as a law, as will the citizens, and therefore it's a legal structure. If you're not a legal positivist in that vein, you could follow other approaches. Ronald Dworkin suggests you trust to Judge Hercules to make the interpretation of the body of laws and to recognise the law and apply its principles. And there are other alternatives. Fuller's morality of law, which is described by Nikki Lacey as the clear separation between our understanding of how to determine what the law is and our criticisms and visions of where it may be. You could apply that. You could apply polycentric law. it doesn't really matter. We have a whole variety of principles that we use that will almost in every case tell us that this is a valid law. It doesn't matter which one you use, it's a valid law. But in each turn, when you apply these, you're defining it by reference to the old world, the world of atoms, orders, sovereigns, and lawmakers. Now my question is, we have a different world today. We have a world of bits, pipes, networks, and platforms. So can we do the same thing? Can we apply these principles to find a rule of law? So, how do you define and recognize law? So there's kind of two ways to do this. One is, I've called these two rabbit holes. One is the rabbit hole marked jurisprudence, which is actually kind of telling you how to recognize laws, and the other is actually the proper rabbit hole called identifying the rule of the law. And the difference between them is one rabbit hole leads you to Hart and Dworkin, and one rabbit hole leads you to Dicey, mostly. So I think you can actually use either of them to kind of demonstrate that there's things wrong with our understanding of law when we apply it to cyberspace. So let's start with the definition of what the rule of law is. Now, this is where it gets really interesting for those of you who are lawyers. You'll probably know this. The rule of law, which is the basic foundational underpinning of law, nobody actually agrees on the definition. There's lots of definitions. There's thick definitions, there's thin definitions, there's something in the middle definitions. So I have a formal or thin definition here, which is, at its core, the rule of law requires that government officials and citizens are bound by and act consistent with the law. This basic requirement entails a set of minimal characteristics, and then it describes 6 characteristics. The law must be set forth in advance, that is, be prospective. The law must be made public. The law must be general, must be clear, must be stable and certain, and be applied to everyone according to its terms. In the absence of these characteristics, the rule of law cannot be satisfied. So that's the most basic term of what the rule of law is. You can add thickness to that, such as T.R.S. Allen's principles of institutional fairness and justice and liberty, and questions of natural justice. The thicker you get, though, the more you start to stray more into social welfare, and the more you start to stray back into politics and political theory. So I'm going to try and just keep to the absolute thin, fine definition, so we don't fall back into the same criticism that you're leaving the lawyers behind and going further away. So, do we find a thin definition of the rule of law on the internet? Well, I don't think we can. And I'm hoping to show this both theoretically and empirically. So if we start with the theoretical, we must begin by defining our space and our participants. So this was the root of a now long forgotten debate in the 1990s between classical libertarians and Berkman School of Chicago thinkers. It was a debate between David Johnson and David Post, and amongst others, Lawrence Lessig. Post and Johnson said the internet was not susceptible to legal control due to the lack of physical borders online and limits to territorial legitimacy. So what they pointed out, in essence, was that a lawmaker who passes a law, they are only legitimate in that law as opposed to their citizens, people who are subject to their law. So if the UK government passes a law saying you shall not defame people, that is only legitimate as against us in the UK. But the point that Johnson and Post made is because there's no borders on the internet, you will affect people outside your jurisdiction. And that this is not legitimate. This is illegitimate because they have no authority or legitimacy to control you. And Lessig and others answered this by showing that you don't need to use laws to control people online, you can use other modalities. So the question of borders and legitimacy became less important. So we got what became Lessig's code argument, which uses an external perspective to treat the internet as a telecommunications network. And once you break it down and make it that way, then it becomes a simple thing of regulating the pipes, not the content. And then that gives you back the legitimacy because the pipes are in your country. And actually, if you don't mind, just for a second, there's a little aside to this, so I'll come back to the main point in a second. The problem with this then comes about the effect of this. All the pipes that go through the United Kingdom are technically, legitimately regulated by the UK government. One thing the UK government does is they issue an interception warrant under the Regulation Investigatory Powers Act for all material going through pipes at certain points in the country, which are then intercepted by GCHQ. This is part of a process known as Five Eyes Agreement, which is shared information and is part of an ongoing data gathering process. Now, most of the data, though, they gather is not about individuals who live in the UK. Therefore, I'm working at the moment with a group called Privacy International, who are seeking to be able to bring an action in the UK to prove that the interception warrant is illegal in terms of intercepting data that was gathered about a citizen in Nigeria. Because they are saying that what's happening is that citizen had no opportunity to protect their data because they were unaware of an interference that was occurring in another state. And they're trying to bring an action here in the UK to show that the actions of GCHQ are illegal in doing this. I'm not sure we'll get very far. The fun thing we're trying to do is we're trying to be the first applicants who are not from the government to argue that the case must be heard in a closed intelligence services tribunal. The government's always the ones that ask for that, but this time we're asking for it, and we have a witness who has intelligence services clearance, who can then appear before that tribunal, who signed the Official Secrets Act. Anyway, that's just by the by. So what we get following this is kind of the concept that you're controlling wires and not the content. But the point that Johnson and Post made still, as I said there, that little story rings true. The acts of traditional state-based lawmakers will exceed their authority due to the borderless nature of the network. So if we take a couple of simple examples, a decision by a court in Sweden to close down the Pirate Bay affects not only citizens subject to the jurisdiction of that court, but citizens globally. So if I'm a UK-based musician who distributes my contents via the Pirate Bay, the decision of the Swedish court to close down the Pirate Bay affects me directly, even though I'm not subject to that jurisdiction or court. Now, you can also think about spillover effects. If the American government closes down Starbucks for tax reasons, that you can buy your coffee at Starbucks in Holborn, which is fair enough. Similarly, if an English court order requires that the identity of a philandering footballer is not revealed, then orders a website upon which this may be found and remove that offending content, it actually affects individuals in Italy, Canada, or even Scotland. Just reminding people that Scotland is a separate jurisdiction. Now, you might feel that the Swedish or the English court decisions are not strongly felt outside their jurisdictions. The network will root around itself, the legal intervention as if it were, will treat it like damage, and eventually everything will carry on as it is. UK citizens will still access the Pirate Bay using a mirror site, and Scottish citizens will call him buying gigs. That, though, misses the point that we have these extrajudicial illegal effects. It's not in compliance with the rule of law, strictly in compliance with the rule of law. And it's much bigger spillover effects than the odd case where a multinational company is closed down in the US and affects people elsewhere. It's much more commonplace than this. It's also only the start of the journey. For the response of the lawmakers faced with failure of their legal interventions will be to take further and more restrictive legal interventions. So a citizen subject to the courts of England and Wales offline, we can become subject to multiple overlapping legal controls online. Actions that we might complete externally viewed in the comfort of our own homes may be acts which, from an internal viewpoint, are committed elsewhere and can actually lead to even extradition or other actions being taken in other parts of the world. So you're all sitting there thinking, yeah, but this is all theoretical, this is imaginary, it's never going to happen in the real world. Well, last year, Yasir Asfar, a British citizen, was subject to an extradition request from the United Arab Emirates. What had he done? He wasn't a nice man, I should say this. I'm not defending him, he's not sort of husband of the year. He threatened to place naked images of his ex-wife online unless she gave him money following their separation. Now that's not nice, and I think we can all agree that. And legally, he may have committed blackmail in the United Kingdom, but he was never investigated or charged in the UK. Instead, the UAE government sought to extradite him for the charge of breaching the UAE law, offending family principles or values by publishing online user pictures infringing privacy or family life. If found guilty, he could face a prison sentence of between 1 and 5 years and a fine of not least 50,000 dirham. In the event, the extradition was not allowed, not because the UK courts were concerned that this was an extraterritorial effect of a UAE law on a UK citizen and there was no equivalent provision in UK law, it wasn't allowed because he was an ethnic minority citizen and there was a concern he would not have a fair trial in the UAE because of his ethnic minority status. So, you know, he wasn't Arab, essentially, and that was the real concern. Otherwise, they would have happily probably extradited him. Also, in 2012, more famously, Richard O'Dwyer, a Sheffield student, was subject to an extradition request from the United States with regard to the operation of a website called TV Shack. And the extradition request followed the decision of the Southern District of New York to bring 2 charges against him for criminal copyright infringement and 2 charges of conspiracy to commit copyright infringement. Each carried a potential maximum sentence of 5 years in prison. Now, I've looked closely at what O'Dwyer was doing, and he's in a grey area in terms of English and Welsh law. He may have been in breach of section 107(2)(a) of the Copyright Designs and Patents Act, but the application of the admittedly non-binding Crown Court decision in TV Links suggests his actions were arguable within the United Kingdom. In the end, he wasn't extradited, again not because the British courts defended him from extradition, but because he entered into a plea agreement with the New York court. And TV Shack was closed, and I think he had to pay in damages into the court, if I remember rightly. So he very nearly was extradited for doing something not illegal in the UK, from the UK. And this is only the tip of the iceberg, and this is the interactive section. Are you certain nothing you have ever said online breaches section 204 of Nigeria's criminal code?
What is that?
You mean you don't know? You go online. You go online in ignorance of this really important legal provision. Section 204 of Nigeria's criminal code, for those of you who may have broken it and fear extradition to Nigeria, any person who does an act which any class of persons considers as a public insult on their religion, with the intention they should consider the act such an insult, and any person who does an unlawful act with the knowledge that any class of persons will consider it such an insult, is guilty of a misdemeanor and liable to imprisonment of for up to 2 years. Okay, what about section 133 of the Thai criminal code?
That's the noblesse oblige.
It is! You see, we have one person who can safely go online and interact with Thai online communities, safe in the knowledge that they're not breaking the law. It is. It says, whoever defaming, insulting, or threatening the sovereign, queen, consort, heir apparent, or head of foreign state shall be imprisoned as from 1 year to 7 years, or fined as from 2,000 to 14,000 baht, or both.
I had a Thai student who was a journalist writing in English in Bangkok and came very close to falling foul.
It's a major plank of the Thai cultural identity. And so it's one, they're not like they start plucking people from overseas, but it's something that's taken very seriously in Thailand. So my question is, what does this mean for the rule of law? So I'm going back to our thin principles. The law must be set forth in advance or be respected. Yes, I think we can all agree this is the case in all these cases. The law must be made public. Well, you see, this is where it gets slightly trickier. Well, many laws around the world are made available online. Not all are. They are public in the sense that they're in libraries somewhere. But as somebody overseas, can you actually access them? I couldn't find the relevant UAE law from the Asfar case. And many of them are not available in translation, which could be a real challenge for the rule of law, because being made public also means understandable and accessible, not just physically there. It must be general. In this cases that I think they are general, but we don't know for all laws in all jurisdictions. I think in the instant cases they are, but it's not sure. Be clear. Well, again, this is very tricky. Even despite language issues, there are so many cultural references and procedural references which are completely unclear. For example, a simple thing. Nearly every country has a provision which says it is illegal to distribute indecent images of a child. Okay, how old's a child? If you have an indecent, I'm not suggesting anyone has, sorry, if you have an indecent image of a 17-year-old on your computer, are you safe to go through customs in Japan, for instance? Not that you should have it in the first place, because when you come back to the UK, they'll arrest you here. The answer is no. Japan is 18, the same as the UK, and that's because of the Council of Europe Convention on Cybercrime, to which Japan is actually signed up to. But there are many countries which are different. The age age of majority in Mexico is 14. So technically, if you have an indecent image of a person 17 on your computer in Mexico, it's not illegal. But, there's definitely questions of morality. So that question of laws being clear are not clear unless you understand so much more about law and culture within these societies. The law must be stable and certain. Now, individually, each state might have stable laws in terms of the rule of law, but collectively, the churn across all of the jurisdictions we're talking about here, I think makes the law quite unstable. For example, I asked this to a room full of experts in cyber law. Is the French Hadopi law still in force? The French Hadopi law was the law in France that allowed for infringing copyright material to be subject to warning notices and eventually for people to be disconnected. So it's a major law in terms of online. And I asked this room of people, and most of them could reply. And there's a few sort of experts in this area in the room. Is the Hadopi law still in force?
The last I heard it was being withdrawn.
Last you heard it was being withdrawn. Richard is a bit more confident it has been. Yeah.
I remember that there was a decision of the Supreme Court that said it is unconstitutional, then I don't know.
Yeah, it has been. It was revoked on the 10th of July 2013. So it's revoked. But I mean, we're experts. And people going, yeah, I think so. I remember it. So this is a question about this mass instability. Be applied to everyone according to its terms? Yes. In fact, I think this is the problem. It's being applied to everyone, potentially everyone, not just people within the jurisdiction. Individually, each jurisdiction can comply with the thin definition of the rule of law. But when we start to get extraterritorial effect, and we're seeing this more and more, there's also cases like Kim.com at the moment, who is fighting extradition from New Zealand for what is essentially a breach of American law, rather than the New Zealand provisions. The thin definition is undermined, and I think the rule of law breaks down. In essence, we're replaced not with a rule of law, but a rule of laws which are overlapped and which conflict with each other, and undermine basic principles of the rule of law. The problem, therefore, is we're trying to apply two different perspectives, one which you might call the internal and one which you call the external. So just looking at the time, what I'll do is I'll skip the last little bit, which is not necessarily important, and just explain a little bit about where the problem comes from, and then come to the conclusion of what we need to do. The problem actually comes from, there's a great article by a very good Canadian professor called Orin Kerr, where he talks about the internal and external perspectives of the internet. Now, the internet is two things at the same time. This is one way to look at it. It's two things at the same time. The external perspective is the network is cables, essentially, and it's servers, and it's computers, and it's just something that connects to the physical environment. So when we think about controlling it or regulating it, we think about telecommunications law. So you regulate it in the same way you would a telecommunications network. The other way to think about the network is called the internal perspective, and this is the network, it's a social place, it's a space we go to. So you think, what am I doing online? I'm somewhere, I'm in Twitter, I'm in Facebook, or wherever. You imagine yourself traveling there. Now the trouble is both are true, but they produce different kind of regulatory outcomes. So if you said to a UK citizen, let's imagine for the moment you've got someone who's a right-wing white supremacist. They might say, I like to go and take part in American discussion boards where we can have freedom of speech and the First Amendment. And for them, they've left their sort of physical corporeal plane, they've gone to the US, they're subject to the laws of the US, and they have the freedoms that are there. That's their internal perspective. From the external perspective, they're still here. Their computer is still here. Physically, they're still within the UK. Now, in essence, both are true, depending which perspective you take. Now, for the rule of law, what you need to have is a consistent perspective. It doesn't matter as long as it's consistent. So either you say consistently, we apply the external perspective and we treat it like a telecommunications network, or consistently, we apply an internal perspective and we treat it like a physical place you go to and an online separate place. Either of those would work, but what in fact is happening is governments and lawmakers are applying both. depending on which one is better from their point of view. So for example, there's a few examples that Kerr gives. One is a search warrant which was executed by the FBI in relation to a drugs bust. So the search warrant says that they have the right to search any and all material found on the property being defined as a specific street address in New York. They hammer down the door, presumably having first politely knocked and asking if it's okay to come in. They hammer down the door, they go in, they round up the suspects, and they go searching the house. Now, one of the things they find is they find a computer. The computer is logged in, it's open, there's no password protection or anything on it, and the computer has an open connection to a cloud server. The data on the cloud server is not physically in that address, it's physically somewhere else. You know, it's on servers somewhere in a different state probably, never mind a different address. Despite this, the FBI decide that this is within the property, and they take the data. And they then keep to bring it in court. When it's brought before the court, the challenge is brought forward that this is not material that was covered validly by the search warrant. The court applied kind of internal perspective and said anything that was kind of found within the house, even if it was physically located on a server somewhere else, was inside the house. Prospectively, it was there. It was inside the property. And this is permissible, which of course was great for the prosecution, because it meant that they got to be able to adduce this evidence. A competing case where you have a young, lovelorn individual within a state, I can't remember what state it is, it may have been Utah, I can't remember. His girlfriend has dumped him, and he's feeling a bit down about this. So, as all sort of late teenage, lovelorn young boys do, he sends her a death threat by email. Okay, maybe not all, maybe it's just me. He sends her a death threat by email, which is not nice. Again, I'm not saying people involved in this are nice, but it's a question of the rule of law. So he sends her a death threat by email. The courts then, well, actually not the court, the action is passed on to the FBI rather than the local police. Why the FBI? Because it's a threat which crossed state lines. But hold on a minute, I live here and my girlfriend lives basically a 3-minute walk away round the corner. Ah yes, but the email you sent went from your computer to a server in another state, and then another server in another state, and then back to your girlfriend's computer. So it actually crossed state lines twice. And therefore
there's precedent for that, which is in kidnap law.
So
Kidnap law is automatically regarded as FBI now.
Yeah, yes.
Because a person might have crossed the state line.
It's exactly the same
We've
principle.
actually got a physical there, so what's new?
Well, what's new here is they're applying a different provision. Now, this time they're taking, gosh, that is really echoey there. This time they're applying the external perspective. So it's the opposite to the other case. It's this lack of consistency. This is the problem. Neither approach is wrong.
But what I'm saying is it's not different from the law as applied to kidnap.
No.
Where they apply an internal and external perspective simultaneously to justify FBI intervention in any kidnap case.
Do they?
I've
I've got to admit, I didn't know enough about the federal law in terms of kidnap and when.
It's automatically an FBI case.
It may be because it may have crossed state lines, because you must
Because you
assume.
may have.
Yeah.
Not because you have,
Yeah.
because you may have.
I see what you're getting at.
Yes.
I presume that's the way the FBI gets involved.
Yeah.
The assumption is you may have crossed state lines, therefore it's a federal issue
Yes.
because potentially the interest.
Yes.
That is a good point, actually. I might need to think about that and see where this fits into
Yes.
because that's quite an interesting point. But the problem we have is this switch between the two perspectives. This is the bit that's undermining the rule of law. This is the bit that means we don't have this consistency because the lawmakers aren't following a consistent approach, and it makes it impossible for us to know what's actually going on. Nevertheless, the international sort of aspect of it. So where does this go? Well, I think in the abstract, I probably promised some kind of map that we could go on to identify rule of law, but I've already spoken for an hour, and you can probably guess by now you're not going to get that. Instead, this is the project I'm kind of working on. This is kind of the prior state. What I can tell you is I think that the map is to be found in looking at Oren Kerr's divide between internal and the external view of the network. And as long as lawmakers, courts and other bodies attempt to use both, I don't think we could ever have a proper rule of law for the internet. They want to cherry pick whichever point of view that they want to use. So we have lots of cases, United States versus Camersal about bomb threats, United States versus Thomas and obscenity distribution, and various others. And that's only at the micro level. At the macro level, it gets considerably more complex. Now, what I plan to do to actually make this into something more concrete is, the wonderful thing is that I've said there's no paper because I've been busy. Next year I'm not going to be busy. I have a lovely year's sabbatical. And hopefully something useful from this is going to come out of this. Actually looking, and my idea is I'm going to spend some time talking to really interesting people who are transnational lawyers. Because this is what they deal with all the time. Transnational financial lawyers, transnational environmental lawyers, all these kinds of people, this is what they deal with all the time, the problems of overlapping jurisdictional issues. So it's not impossible to solve. But the interesting thing is, this is my last point, about what is the role for cyber lawyers, is that I think if I do that, I'll be the first person who's a cyber lawyer to have done this, to have looked in this way. Which is really maybe what cyber lawyers have been doing for a long time, and we would have been doing if it hadn't been for Frank Easterbrook, who sent Lawrence Lessig off in the wrong path and dragged us all behind him. And then maybe what I will find is when I go back and talk to colleagues in the law department, they will say to me, "You're a lawyer. And we're really pleased to have lawyers in this area." That's not to say that I think we should forget, at the point you made earlier, it's not to say that we should forget there's much bigger things out there than law. I just for once would like to be able to have coffee with my colleagues who are lawyers and maybe speak the same language as them. So apologies for that slightly perhaps disjointed, and I look forward to any more questions. I mean, and you can, can you interrupt me? Yes, but just try, and once I started speaking, it's almost impossible. So any questions or observations, I would be delighted to hear them. Sorry.
Any questions?
Oh yeah, I got one.
Stunned silence follows. That's the usual response when I do these things.
But I don't want to preempt it yet.
I don't think you are, Roger.
No, okay.
It's helping me, but I'm all right.
I think, Andrew, that Lawrence Lessig didn't actually lead us all together. I do sympathise with the thrust of what you're saying, that having to kind of justify cyber law as a state domain for lawyers, respectable work. But I think there was a deeper insight in Lessig.
Oh yeah.
Which, was that the way that social ordering will be implemented in the future is going to be less reliant on normative modalities. So it doesn't matter whether you're talking about law as we now characterise it, or ethics, or religion, or just info. I mean, this is going to be an old-fashioned way of trying to get to regulate. And we first see it coming in Lessig remarks about code as a regulatory modality. But I think that that particular way of trying to do things, whether it's through Google cars or just the software in IT systems that Lessig was thinking about, this is the future. Now it's not going to be a future that just happens overnight, but incrementally we're going to find we're going to find ourselves in managed environments where it's just the technology in that sense that does control. And in fact, I've just completed the first chapter of a new book I'm writing, which is called In the Year 2061. And 2061 is 100 years after Hart published the concept of law. And just to go back to it, now this is going down the jurisprudence rabbit hole, but in Hart we have these famous discussions about what the external observer will make of the movement of traffic at a set of traffic lights. Yeah. And Hart's point here is the external observer will observe the pattern of the traffic, that when the lights go red, cars stop generally, and green they go. But Hart is saying here you miss out altogether on on the distinctively internal aspect of law. And of course, this is perfectly true of rule-governed situations. Now, it seems to me that in 2061, I'm not quite sure how the traffic will be controlled, but I'm pretty damn sure that if there are still traffic signals out there, it will be the signals, the technology that does control how a future driverless car, driverless car. But so the point I would make is that I think that in the 20th century and before, when rule governance was the only way we really understood about how to maintain social order, there was a systematic failure, whether by positives or the critics, to anticipate a future where technological management would take over. And now Ian Kerr, who you mentioned, he has some great examples about supermarket trolleys and golf carts that, I mean, there's a club in the Midlands called the Warwickshire Golf and Country Club. If you go on their site, you'll read about a problem they had in 2011 with local lads taking golf carts away to joyride. So what they did was fit some GPS on the carts, and now, as they put it, there's an invisible barrier around the golf course. And indeed, people playing legitimately on the golf course too, they find where the greens are being repaired or there's a problem with waterlogging or something. They can't take the carts there. They can't. I mean, they're immobilised if you try and take them anywhere near. So, but the interesting point about the joyriders is